Good evening, everyone, and welcome to Farmers Weekly's Resolving Disputes webinar. I'm Susie Horn, Farmers Weekly's business editor. I grew up on farms in East and North Yorkshire, where my brothers are arable and sheep farmers. First of all, thanks to everyone for joining the webinar. I'm sure it's going to produce lots of discussion afterwards, and thanks also to our panel for their time and expertise. We're going to have three short presentations, and then we'll open up the discussion and deal with some of the questions that we've had in advance. Obviously, this is a huge topic, so it could be disputes of any sort. We've had a lot of advanced questions on family type disputes, but please do put in your questions about any other type of dispute, and we'll try and deal with those. So I'll introduce our panel first, and then do a bit of housekeeping about how things work. First of all, we have James Stephen. James is a Carter Jonas partner. He heads up the firm's rural team in the southwest of England. He's got many years' experience as a rural practice chartered surveyor, covering a wide range of farming and land management advice. Then we'll hear from Russell Reeves, who's he's head of Thring's agricultural litigation team, specialising in advising on and acting in all forms of disputes for farmers, agribusinesses and landowners. Again, across a very wide variety of issues, ranging from family farm partnerships and inheritance disputes to disputes about property, land and farming goods and services. Then we'll hear from Carly Drummond, who's a senior tax manager at Accountant MHA. Carly's got a special interest in and experience of capital tax planning, and she's helped many farming families through the succession planning process with a tax efficient but very practical approach. So after the presentations, we'll open up things for discussion. We've had lots of questions sent in advance, so we'll get answers to as many of those as we can, and the ones that come in during the webinar. If you want to ask a question while the session's live, you've got a box at the bottom of your screen. Just type in your question at the foot of your screen, and then I'll direct those to the panel once the discussion begins. The webinar lasts for about an hour and a quarter, and then afterwards it will be available to view on demand, and you'll get an email to let you know when the recording's ready for viewing. There is just one caveat. Obviously, all of our panel are experts in their field with lots of experience, but every case is different. So just wanted to say, don't rely necessarily for your own business on something that you hear in the webinar, but hopefully it will, as I say, provide lots of food for thought and some discussion afterwards. Thank you. So we'll go first to James Stephen from Carter Jonas. James.
Good evening. Thank you, Susie. As a land agent, I think our role is probably, or should be, focused on reaching agreements and avoiding disputes. And my experience over the years is prevention is most definitely better than cure. I know that's easily said, but there are a few key issues I think that we all ought to be aware of to avoid disputes arising. The first one, and they're fairly obvious, but I think they're worth repeating because quite often a lot of disputes, when you actually get to the bottom of them, relate to these key issues. The first is clear communication. That sounds really simple, but I totally understand it's not always that easy sitting around in a family situation. Everyone will say, oh yeah, we speak to each other every day. Well, that may well be the case. You sit around and talk about beef prices or milk prices or fertilizer prices, whatever. But you don't often sit around and have a detailed discussion about how the ownership of the land will be passed on, what you're intending to do in terms of apportionment of value between different siblings, some who may no longer work on the farm. All that sort of thing is really important. And I would say lack of communication, unclear communication, contradictory communication are all things that can contribute to family disputes. You know, this will all be yours one day, my son or daughter, is one of those things that leads to these proprietary estoppel sort of disputes we've all heard about, where someone stayed at home, worked on the farm, probably not being paid a huge deal, and then suddenly finds at the end of the day what they were expecting to happen when mum and dad died didn't happen. And it's because there hasn't been clarity as to how or clarity of communication between all family members. That doesn't only involve family members, though. Clarity of communication with your professional advisors, I think, is absolutely key as well. For example, you might have your lawyer has gone off and prepared a very sensible will, and your accountant may have gone off and decided that you should incorporate to save tax for some reason or another. But unless the will reflects that you've now got a new corporate entity in place, it may result in very much the wrong result. So getting your lawyer and accountant, and I know this doesn't always go down very well because it's expensive, but occasionally you do need to talk both with yourself and your professional advisors as a group and make sure that you all understand what you're doing, rather than just treating the will as a standalone exercise, and maybe your business planning with your accountant as standalone exercise. You need to, I think, talk together. And one of the issues is the increasing value of land has made all these disputes more likely, frankly, because, you know, children who have headed off not on the farming or landowning business, or you know, they've gone off making their way in the world, and then they look back and look at a farm that might be worth, you know, several £1 million, and they sit there and say, well, why, you know, what are we doing with that? Why are we leaving it like that? So that is communication, clear communication. But what you then need to do, I think, as far as you possibly can, is record what's been communicated in writing, whether that's a will, a partnership dispute. A partnership dispute is a common one. How is the partnership going to be brought to an end? How are the assets going to be valued? All those sort of things. If there is a dispute, how is it going to be resolved? Will it be arbitration, expert determination, all that sort of thing? You need clarity in writing as to what you have agreed. And that applies to all sorts of agreements, whether it's contract farming, tenancy disputes, development agreements, etc. If, however, you find you're in a dispute situation, what do you then do? I think before you rush off to go and go to court or whatever, just sit back and decide whether, I don't know, some form of effective negotiation can be brought into place, non-adversarial. So can you get someone, for example, an outside professional or some respected party, can you get them to sit down around the table with you and try and agree, you know, assemble and understand the facts, decide what the objectives are, consider a realistic bottom line, for example, understand, you know, the potential financial and emotional costs of going to court if you decided to do that, and keep a sense of realism and perspective, I suppose, in the whole thing. Don't let your emotions overtake your the sense of what you're trying to resolve. And so sometimes you can get an independent, non-adversarial person just to come around. It could be family friend, it could be someone who's trusted by all parties, and just see if you can avoid the dispute. If you can't get anywhere with that, then you will probably have to head off to some form of formal dispute resolution, whether that's mediation, which may not be binding, or arbitration for a tenancy dispute, or expert determination of the court. And I think really my summary is try and avoid the dispute. Clear communication is everything, and record what you have clearly communicated in writing. And hopefully that'll avoid disputes. But, you know, somewhere along the line, disputes do arise. And I suppose it's over now to Russell or Carly to talk about where disputes do arise.
Thank you, James.
Right, thanks, James. Yeah, sorry, carry on, Russell.
Thank you, James, very much. All very good advice. I'm going to talk about four things. Firstly, just a very quick introduction to our firm. Secondly, I'm going to talk about the areas of disputes we cover. Thirdly, I want to talk about the different ways in which disputes can be resolved. And then finally, I would like to talk about the factors which influence people's approach to disputes, and perhaps sometimes prove obstacles to disputes. So to begin with, I am a partner in Thring Solicitors. We're one of the largest, we've got one of the largest teams of agricultural experts in the country, and we act for farmers all over the country in all forms of disputes, and we have done for many decades. I head the agricultural litigation and dispute resolution team, and the areas of disputes which we cover can be grouped into different sort of legal categories. So we deal with, for example, contract disputes arising between farmers and people supplying services within the farming sector. That can include defective machinery, for example, milking robots, drilling machines, defective tractors, that type of thing. The next category is negligence claims. That's claims against professionals sometimes, including agronomists, vets, surveyors, people like that sometimes. The next category is nuisance claims, and what that means is sometimes when something on your land escapes onto your neighbour's land and causes damage, such as water, for example, or oil, that sort of thing. Another really big area of law that we cover is sort of land law and all forms of it. So lots of rights of way claims up and down the country. What we call squatters' rights. The word for that is really adverse possession, and boundary disputes and that sort of thing. So all forms of property disputes. Partnership disputes, James has touched on, also within a family context, a growing area, typically arising when you've got a retiring partner or a partner that wants to leave the farm. Perhaps the other partners want him away to leave the farm, and you can then get disputes as to what is the correct valuation basis for the assets, who should get what. And sometimes there's a question, it might seem bizarre, but a question as to what are the assets of the partnership. Now, you may think you know, but it's the fertile ground for lawyers as to what assets can be assets of the partnership. Sometimes, for example, land registered solely in the parent's name, for example, but it's brought into the partnership, and the question is whether it's a partnership asset or not, and accountants can play quite a big part in that. And we speak on that later, I'm not sure. Another growing area is an inheritance dispute. We acted on the recent Guest versus Guest case at the Supreme Court successfully. So deal with a lot of those sort of promises cases. And then finally, we actually represent farmers when challenging the authorities in sort of health and safety cases, environment cases, gangmasters license cases, that sort of thing. So next, I just want to talk about different ways to resolve disputes. Court proceedings is what everyone thinks about when you think about it involving lawyers, but I would say about 70% of the cases I deal with have no court proceedings involved at all. That is perhaps because that there are rules of court known as the civil procedure rules. And what those rules say is that when there's a dispute between two parties and when lawyers are instructed, one of the first things that a lawyer acting for the claimants has to do is write what's called a letter before action, also known as a letter of claim, and send it to the other side, or solicitors if acting for the other side. The other side then have, that letter has to set out basically what it is that is being claimed, why it's being claimed, and what's being sort of demanded as a result. The other side then have a reasonable period of time in which to respond to that claim, and that's deliberately not a set time frame, because what's a reasonable period of time in a very valuable case involving lots of expert evidence or difficult questions, that could be a very long time. But what might be reasonable in a much simpler case might be a shorter period of time. But generally speaking, you write a letter to the other side, setting out what you're claiming, and then within about a month, as a guide, but sometimes it can be longer or shorter, the other side have got to respond, setting out their sort of points of dispute. That then crystallises the issues, so you know what the issues are in dispute. One option is then to issue court proceedings if you can't resolve the dispute, but there are other avenues, and James has mentioned some of those. So one of those is mediation, for example, and that's a situation. It's a non-binding, as James said, sort of procedure whereby both parties, they have to be in agreement, both parties agree to instruct a mediator who typically spends about a day with the parties. The parties tend to be in separate rooms, which takes a bit of the hostility or confrontation out of it if it is a hostile or confrontational sort of relationship. And the mediator will go back and forth between the parties, trying to sort of knock heads together and prod and probe areas of weaknesses, areas of strength, and try to come up with a solution. Now, it's crucial, it's non-binding. The mediator isn't a judge. The mediator can't make any binding decisions on the parties. It's a voluntary process, but about 98% of mediations are successful. So that's a way to resolve disputes potentially without going down the formal court proceedings route. And the mediator's fee is normally shared, and typically it's in a neutral venue. So that's one option. Arbitration is another option. That's typically where the parties agree by way of an existing contract. Many existing contracts have arbitration clauses which say in the event of a dispute, the parties have got to go to arbitration, for example. And if that is a clause, then you do have to go to arbitration rather than court proceedings. And that is similar to a judicial process in the sense that the arbitrator does have a binding authority to make a decision and to bind the parties, but that is another option. There's also the option of what we call without prejudice letters. You've probably heard the term. In law, you can write open letters, which are letters that can be seen by the court at any point in the proceedings, and at the same time, you can also write what we call without prejudice letters. So an open letter might say, these are all the reasons why we're going to win our case, and you send that to the other side. And then you write a separate without prejudice letter, which the judge will never get to see. And you can say, look, despite what we say in our open letter, we recognise that it's in the interest of all the parties to try and resolve the matter, to try and avoid further costs, and to sort it out. And these are the ways in which we suggest we can sort it out. So without prejudice correspondence, that's another avenue. And then finally, I just wanted to talk about the different factors which can influence the resolution of disputes, because it's a corny phrase, but it does take two to tango. You do need both sides to want to resolve the dispute, otherwise you're not going to resolve it. But some of the factors that can contribute towards that, firstly, I think the merits of the case. And I suppose I agree with James. It's sometimes cheaper to resolve cases without the need for lawyers. But will he be resolving it on the sort of optimum terms? And I think in order to know that, you need to have some idea as to the strength of your case. If you've got a really strong case, you might be less keen to settle it. Whereas if you've got a weak case, you might be more keen to settle it. For example, so the merits of the case do play a part. Secondly, the party's attitude to risk is an important factor. There are different people out there. We've all met them. Some of them are quite bolshy and want to go to court no matter what. They want to have the day in court. They don't care about the risks. There are other people that the last thing they want to do is go to court. I think the majority of the public are in that camp, and they want to settle it, and they'll settle it for something lower than the first person. So attitude to risk is important. I also think psychology is really important in litigation too. Sometimes just a simple apology can avoid a dispute, for example, and particularly in family relationships or where the parties are known to one another, or neighbour disputes, for example, psychology can play a big part. And then finally, before I'll stop, funding. The ability to afford litigation is an important factor. But pleasingly these days, what we call legal expenses insurance is a lot more readily available, and it's often a sort of an add-on that's on your home insurance policy, for example. If you've got a business, your business insurance policy, and it can pay for the legal costs in the event of a dispute, typically to a very large sum, something like 100,000, 200,000. And a lot of people don't know they have that insurance. So if you're ever instructing lawyers in disputes, do have a look at your insurance to see if you've got this coverage, because that might help pay for the fees. Thank you.
Okay, thank you very much, Russell. Plenty to chew on there. Carly, let's hear from you about how you get involved in sorting out disputes or the type of disputes that you come across in your work.
Thanks. Susie. Hi, everybody. Unfortunately, my presentation isn't going to be anywhere near as polished as the other two. And sort of going third, I run the risk of being a bit repetitive here. But essentially, my sort of contribution to this panel, I see it as being sort of from two aspects. The first being disputes you may have with HMRC. As a senior manager, senior tax manager in our MHA, heading up our agricultural practice in MHA, I find that luckily we don't come across too many of these. I think that when we do, we can normally enter into a reasonable conversation with HMRC as sort of experts in the field, to come to a good conclusion with this. So I think if you are coming across any disputes with HMRC, it's one to get on top of as soon as possible. Quite often, the staff dealing with agricultural clients at HMRC will probably not have the experience that myself and my colleagues and other people that are dealing with this, have the luck to have. So a lot of the time, it's a case of us educating them, and that's how we can resolve a lot of disputes with them. I think that hopefully we're going to see reform, potentially inheritance tax, which may make some agricultural relief arguments a little clearer for us to make our case for. Who knows? As case law progresses and things change, and we've got a general election coming up, there may be some impacts there as well. So keeping on top of our reliefs, reviewing our situations regularly, making sure that you're happy with disclosures, that your accountant knows everything that's going on, any potential sales getting in top of them, getting ahead of them, any succession planning, inheritance tax planning, making sure that you've thought it through with somebody who is experienced in the sector, because it is a specialism. We do find that quite often people have people advising them that aren't necessarily agricultural specialists, and it doesn't always translate well. And that's the best way to keep HMRC at bay in our experience. And as Russell has said, the way that you can get this legal insurance, you can also take out fee protection insurance with HMRC, with your accountant usually, which will cover fees for disputes with HMRC. So that's one way of kind of an insurance against HMRC picking up your file and deciding to make an issue of it. So that's my sort of my tax hat, if you like, where I'm coming from there. So just to rewind, then I sort of look after the business consultancy and tax aspects of our agricultural practice. At MHA, we are a national firm with international reach as part of Baker Tilly International, but we do tend to provide as much of a local service as we can. We have a small team of specialists that work together all the time, and again, we can provide help wherever we need to across the country, because it is important that you have got a personal touch on these things, as quite a unique business. The second sort of thing that I would like to talk about here, and it has been covered already to an extent, are the family disputes. So this crops up when we're looking at tax planning, where we have development land coming in, where we have BNG at the moment is very big for us. BNG opportunities coming in that, on paper we're looking at very big numbers, but in reality we're thinking, crumbs, who owns that land, who's going to benefit from that cash, and what are we going to do with it? How do we spread that across the family? A very big thing for me, and something that comes up in nearly every meeting for me, is when we're talking about fairness across family.
Right, looks like we've temporarily lost Carly. Hopefully we can get her back quite soon. Can everybody hear me? Yes.
I can, Susie.
Yeah, good. So perhaps while we're waiting for Carly to rejoin, it's quite interesting that she mentioned biodiversity net gain there and some big numbers. But I guess it's another new aspect of advice in terms of if there's either a big upfront payment. You got you back.
Sorry, am I back? Hello. Sorry, I was slow there. I don't know what happened. Sorry. Should I carry on, or do you want to carry on, Susie?
No, that's fine. I was just filling in. You mentioned BNG, so we were going to talk about that. But the last thing you said was it sort of who benefits from the cash and how to spread that fairly, if indeed you are.
Yeah, absolutely. And I think it's key just to bear in mind that it doesn't mean pound for pound equal. where you've got a reinvestment in replacement assets, that don't in your head get caught up on the fact that that might be a £2 million price tag on one hand, and someone's only getting a much more reduced amount. I think that's sort of key for us. I think where you've got disputes with third parties, disputes with neighbours, local councils, things like that, people are more keen to take the ball by the horn and really sort of assert themselves with those and get them sorted. I think where you've got these underlying issues with family members that sort of remain unsaid and they lurk in the dark and no one wants to pick at that scab too much, that's where we really need to be thinking about how we resolve these. And I think absolutely prevention is better than cure. And I think, to reiterate what James has said, communication is key for me, and I think openness, honesty. If you cannot be in the same room with somebody else, there's normally a reason for that, and we kind of need to think and potentially go back a little bit to see what's happened there to get to that point. And absolutely, sometimes an apology can be all you need to get people working in the right direction, and a bit of context. As third parties, we can often be the impartial person in the middle. As accountants, we have numbers in black and white that we can show people, that can demonstrate where the money's going, who's benefiting from it, the work that's being put into it, where you've got disputes in terms of drawings and things like that. And we quite often end up playing devil's advocate too. I'm quite happy to ask the difficult questions in meetings to make sure that we are bringing issues that could potentially lie dormant for some time to a head now. A very popular thing for us at the moment is prenuptial agreements, and just bringing up in a meeting with son who's about to get married, who potentially has a share in the farm. Well, you are doing one of these, aren't you? And it's much easier for me to raise that rather than potentially dad. So that's sort of where we come from with a lot of our business advisory service, is that we try and tackle things head on. We try and obviously be sensitive about them. If we can mitigate any sort of problem, manage the expectations, then we've won. I think if anything ends up in court, I think we probably would feel personally that we haven't done all we could have done to get to that point. Sometimes it's a necessary evil, but I would hope that in most cases we can resolve things before it gets that bad. So I think really that's what I'm sort of looking at on our panel tonight, is if anyone's got any particular HMRC disputes they want to talk about or discuss, but also it's really the interpersonal relationships, how to manage those so that we don't actually get a chance to have to call in anyone particularly expensive, or you get too complicated with how we resolve things. I think it's about managing expectations early on. It's about making sure your ducks are in a row. Your paperwork stacks up, partnership agreements, shareholders agreements, family constitutions, even if you want to go that far. And often these things are quite often worse in your head than they are to actually bring them out and have that conversation. So it's sort of tackling that head on, I think, is how we deal with resolving disputes, and hopefully before they become disputes, if you like.
Right, that's great. Thanks, Carly. I think we're all on the same page there. And I just want to, before we go into, thank you all for your presentations. Just before we go into the questions proper, somebody's just put in a quick question saying, what's BNG? And apologies, we all get very familiar with these acronyms. It's Biodiversity Net Gain, which is a planning obligation that's going to be on developers coming in from January next year, where they're going to have to increase the biodiversity on their sites by at least 10%. And if they can't do that, then very often they're going to be looking, they can't do it on site, very often they're going to be looking for landowners to provide that biodiversity gain, and they're going to pay landowners to create biodiversity units. It's a new market, just emerging, lots of big figures flying around that you're mentioning.
I that was my point, Susie, was that when you've got somebody that's potentially non-farming seeing that this is happening, and the numbers at the moment are looking very worthwhile pursuing. It's a case of how we manage those expectations within the farm that, you know, potentially we've lost acreage to this development. So yes, we've got some in, but we've got to replace that somewhere else. And, you know, it's having those conversations, I think. And sorry, I apologise for using the acronym. It's something that we're sort of very deep in at the moment. So it's something that rolls off my tongue quite easily. But we are seeing these conversations now happening. They were happening with residential development, commercial development, you know, a few years ago, and now it tends to be where we've got BNG credits to sell.
Yeah, thank you. So we've had a few questions come in during this session. We'll deal first of all with some of the ones that came in advance. First one, we'll go to Russell on this one first. I have a full right of way over an access drive to my farm for all vehicles. What is the law relating to upkeep of the drive by the owners of the drive? The owners of the drive and not farmers. So, Russell, can we go to you first on that one, please?
Thank you. Well, the fact that the owners of the drive aren't farmers, that means nothing from a legal perspective, but I think from a an emotional perspective, or from an appreciation of what farming entails perspective, we all know that can bring about its own problems. The answer lies in what is the origin of the right of way. Rights of way can arise in different circumstances. One of those is what we call an express right of way, which is set out in a deed of easement. And if that deed of easement is drafted properly, it should contain a covenant in there, which we call a positive covenant, saying who's responsible for the upkeep of the drive. Typically, it might be according to who uses it most, or maybe 50% each if two people are using it, and how and who pays for it and when. If it's not within an express deed, the right of way, for example, has arisen by way of what we call long usership or what we call prescription, then the person with the benefit of the right of way is entitled to go onto the right of way and repair it, but not better it. So if it's, let's say, it's stones and mud, the right of way is across stones and mud, you can go in and perhaps replace some stones, put in some hardcore, something like that, but you can't go in and tarmac it on someone else's land, because then you're bettering it. So it really depends on the origin of the right of way.
Thank you, Russell. And we'll go to another one, which is a valuation question. Two siblings, they've been left with 50% share each in a farm. They can't, one wants to buy the other out, but they can't agree on the value. This is something that's been going on for 7 years and unresolved, so they're in a bit of a fix. I think it's not unusual for farming disputes to go on for 7 years or even more, Russell, but obviously the longer it goes on, the bigger the stress and potentially the bigger the bill. So perhaps Russell first, then maybe Carl would like to come in on that one, and perhaps James, but see how we get on. Thanks.
I lost you for a moment then, Susie. Would James mind just going first on that one? Is that okay?
Well, if we go to Carly first on that one, Carly, I don't know whether you get involved in trying to sort out disputes over valuations.
Carly, you're on mute.
You're muted.
Apologies. No, absolutely, we do get involved in these. Our sort of involvement with valuations tend to be with the district valuer a lot of the time, but when you've got a situation like this, I think the tax implications are quite important to consider when you're looking at the valuation piece, because obviously there's going to be a sale, there's going to be the dreaded capital gains tax to consider, so your valuation is very relevant to that. There's ways to mitigate that, so it might be that the tax burden can be part of that negotiation between the two parties, something to consider. I think also, you know, again, without wanting to sound a bit like, you know, we all had hindsight, you know, we'd all be better off, but had the succession planning happened and had that conversation happened in advance of this inheritance, perhaps this issue wouldn't have arisen. So I think we, you know, as much as we try and mitigate what's happened now, and like I say, the tax burden might be something to consider in that discussion. This is something to learn from in terms of this potentially could have been avoided.
Yeah. Okay. Thank you, Carly. Russell, I don't know how much of you lost. It was a question about two siblings having been left 50% each sharing the farm. We can't agree on valuation, and the dispute about the valuation has been going on for 7 years.
Yeah. Well, assuming they've been left it, I'm supposing that they've inherited it jointly. I'm assuming that probate has gone through and ownership of the land is now vested in the two individuals. Unfortunately, if they can't agree a valuation, then the only option is to apply, subject to all of the different what we call alternative dispute resolution mechanisms we talked about earlier, mediation, arbitration, etc. But assuming we can't resolve it, then the only option is to issue court proceedings seeking a declaration under the Trust of Land and Appointment of Trustees Act that the land be sold, and then the net proceeds of sale be split between the parties. So that's the sort of sledgehammer. That's the ultimate option of the parties. But obviously, hopefully, they can agree something. But that's assuming they own it both sort of individually, and it's vested in them, having sort of gone through probate. I mean, if there's a partnership or something like that, if it's owned by a partnership between them, it's going to be slightly different. But that's assuming they own it in their own individual legal capacities.
Susie,
Want to add to that, James?
Susie, we regularly get involved in valuation disputes because, as valuers, the issue is really are the two parties prepared to agree a single joint expert to provide a valuation, which we can present to their respective lawyers. It then can become a point of discussion, or they can appoint their own individual experts, but that tends to involve quite a lot of argument. But if you appoint a single joint expert, agree on someone that you're prepared to go with, at least you have a single valuation to be arguing about. Whether that will, it's not a binding, you can't force them to agree it. And as you say, as Russell's already explained, the sledgehammer is to sell the property and split the proceeds 50-50. But a single joint expert may be one route to trying to look at resolving that dispute.
Just to add on that, although you said it's not binding, and I agree that the parties can agree to make it binding. That's not without risk. So the parties may say, look, I think it's this value, we think it's that value. We can go off to court and we can have everything sold. But why don't we have that single joint expert appointed and agree contractually to be bound by his decision? So the single joint expert in that case is acting like an arbitrator, almost making a decision. But as I say, it's not without risk because it may go against you, the valuation you might not like.
Yeah, thank you. And I guess just going back to valuation, because I know there are lots of arguments about valuation. BNG, biodiversity net gain, nutrient neutrality, and all those other factors that are coming into land uses now, I guess, make it even more of an art than a science, the valuation of land. James?
Well, they are obviously, nutrient neutrality tends to be very geographically defined by the catchment. If you've got a phosphate neutrality issue, it's only the catchment within which you've got the phosphate problem where that would ever be an issue. BNG is an evolving market. And what I do always say to everyone, every piece of land out there could have BNG value. Depends whether you've got the desire to enter into some form of agreement that will tie up your land, certainly for 30 years and possibly for a lot longer, for the receipt of either some annual payments or a large upfront capital sum, for which you may then find you've got very limited returns on that piece of land thereafter, depending what you do with it. So there's the BNG side has got an awful lot of, it's an emerging market, and it's very difficult to fully understand what those values are going to be, and assessing. Everyone gets quite excited about the big figures, as Carly was explaining, but you've also got to assess, one, how much is it going to cost you to get there? How long is it going to be before you can sell all your BNG units and get the money in? And what's the impact on the value of your land going forward? Because if you sell all these BNG units, you may actually devalue the land in the long term. So there's a lot of angles there to look at, and the reality is we're all talking about BNG, but there's not huge amounts has yet actually been done. There's a lot more disputes going on where there's no BNG or nutrient neutrality involved at all, where you've got the sort of dispute you alluded to earlier, where you've just got a disagreement as to what the value would be. And that's where, we do provide a lot of expert witness, sort of single joint expert sort of valuations, often in divorce cases or partnership disputes. And that's it's a big part of our world. And sometimes we end up giving evidence in court, or other times when you produce one of those valuations, what normally happens is you have a huge number of questions come from either side saying, well, you haven't thought about this, and why didn't you do that? And so that's usually how those things progress before they get to court.
Okay, thank you very much, James. Yeah, we've got a huge number of questions to get to here as well. Another one, family. All of you have mentioned family partnership disputes. Excuse me. This is one where it's a family partnership. They have no formal agreement. Very poor relationships between siblings who are in the partnership. The person asking the question wants to leave the current business and divide the use of the land. I'm not quite clear on what they're doing there. Excuse me.
Shall I kick off, Susan, while you're having a cough? I think this is a really good example, picking up on James' earlier point about that not having sort of paperwork in place. In the world of partnerships, if there is no partnership agreement, a written partnership agreement, then the 1890 Partnership Act automatically applies. And as you will guess from its age, it's an ancient act, which doesn't fit modern times, and certainly won't necessarily fit the nuances of any individual business, and therefore it's archaic, really. And where there is no formal partnership agreement, unfortunately, the 1890 Partnership Act says that if one partner wants to leave the partnership, then the partnership is automatically dissolved. And when a partnership is automatically dissolved, what that means is, in theory, everything must be sold, all of the debts of the partnership paid off, and then whatever's left over, what we call the net proceeds of sale, are then split between the partners in accordance with their capital accounts, etc. So it's a nuclear option, which often isn't within the contemplation of the parties when they're entering into a partnership. And it's because there isn't a partnership agreement. So addressing the question head on, if there is no formal agreement, I think the phraseology you used, Susie, that probably means no partnership agreement, then the 1890 Partnership Act applies. Any one of the partners, I'm afraid, can say, that's it, I want to dissolve the partnership and retire. The others may disagree, but tough, frankly. I'm afraid the law is what the law is. And if the other partners do disagree, then whoever a party wants to can actually apply to the court for an order that the partnership be treated as dissolved, or stand dissolved, and then be wound up, which, as I say, is the nuclear option. And it's often the case that the exiting or retiring partner uses that threat, that nuclear option, as sort of a lever over the remaining partners, because the remaining partners might want to continue in partnership. But they can't effectively, but they can reconstitute a new partnership between themselves moving forward. But of course, you've got to deal with assets first.
Yeah, and that's obviously where there's no formal agreement, and you referred to the Partnership Act 1890. The sort of second part of that question, sorry, which I didn't quite get to copying. It's despite the involvement of solicitors, one of the siblings refuses to engage with any letters or phone calls, emails, anything. And that sort of brings in another question that we've had about how do you basically get parties that don't want to talk to each other or are already in a disagreement, how do you get them to the table? And I guess that the answer to that will go back to either mediation or arbitration. But if any of you would just like to comment on that, perhaps starting with Russell in terms of people to the table.
I often find it oddly, a lot of people bury their head in the sand. We all know people that get red letters from debt collection agencies and they sort of ignore them for a long period of time. It can be the same with solicitors' letters, I'm afraid, sometimes. You can't force someone to open a solicitor's letter, read it, and to do something. Your only recourse ordinarily, as a last resort, is to issue court proceedings. And if you want something, you're claiming something, and if the other side are just burying their head in the sand, then what can you do? You can only issue court proceedings, I'm afraid. Yes, you can mediate. Yes, you can have discussions between solicitors. But if they're not engaging at all, well, you can't mediate because mediation requires their cooperation. What I would say is you can write letters and you can say we need to mediate, etc. We need to talk. If they completely ignore you, then what we say is your remedy is in costs, and what that means is under the rules of court, known as the civil procedure rules, a judge has a discretion to penalise a party if a party has behaved unreasonably in litigation, or indeed in the pre-litigation stages. So if you're repeatedly writing letters to the other side saying, come on, we need to sort this out, come on, we need to mediate, if they're ignoring it completely, then you've got no option but to issue court proceedings. Even if you go all the way through court proceedings to trial, even if you lose, you might say, well, the party that buried their head in the sand throughout, they should pay all the costs because they buried their head in the sand. They weren't reasonable, they didn't respond to letters. Had they done so, we might have sorted this out. So you've got that sort of threat that a judge may effectively punish them at the end of the case for not being reasonable.
I mean, in an arbitration case, for example, I mean, I've come across ones where parties have said, "Oh, you're not my arbitrator," and what they don't realise is an arbitrator has been appointed usually by the RICS or something, and it's not a matter of one of the parties saying, "You're not my arbitrator." Unfortunately, the arbitrator has been appointed is your arbitrator, and if you decide not to turn up to an arbitration hearing and don't present any evidence, that's all that the arbitrator can go on. And if one party's presented a load of evidence and the other one hasn't turned up, you're going to end up with the arbitrator basically awarding in favour of the person who turned up and gave evidence, because that's the only evidence put before him. Mm-hmm. So, if someone completely decides to not engage whatsoever, it's likely they're going to end up being the loser ultimately.
Just to add to that, once court proceedings are issued, the other side can't really ignore it, because once you issue court proceedings, the other side have 14 days to respond. And if they don't respond, you can ask the court for what we call judgment in default. In other words, an order that you win. So if the other side don't respond within 14 days, apply for judgment in default, you win automatically. So at that point, the other side really have to pull their head out from the sand.
Okay, thank you both. We've got quite a lot more family questions. We'll do a couple more of those, and then I'm quite keen to get on to some of the more sort of commercial and neighbour disputes. So in fact, we've lost Carly briefly. So if I go to Russell on one of those neighbour disputes, probably, and then we'll come back to family ones. It's about a right of way over a private farm tract. Do I need council approval or permission to confine the public footpath / pavement to one side with an enclosure fence to separate and safeguard the public and their dogs from moving farm vehicles? Any advice there? Definitely one for you, Russell.
Well, that sounds like a public right-of-way, as distinct from what we call a private right-of-way. So a public right-of-way, and it all depends on the where the public right-of-way is defined and how it's defined. If, for example, its definition includes a specific width, then you can't interfere with that width. But quite often it won't be a specific width. If you can look to move the right-of-way by application to the local council. You've also got a duty under the Occupiers Liability Act to protect anyone coming onto your land, which includes any walkers or people using the public right of way. So it's a very sensible thing to do to try and guard against any danger, for example, from livestock entering the right of way. But it might also be very expensive for you to do that or to fence it, because depending on the length of the right of way, I suppose. Best practice is to involve the council at an early stage. As long as there is still access along the right of way, then the council are likely to be cooperative with allowing you to fence it to the extent you need to keep passers-by safe, as long as you're not restricting the width unduly or indeed blocking it, which you're not allowed to do.
Okay, thank you very much. And another neighbour one. This is a farm with a non-farming neighbour who has 4 or 5 dogs. They're rarely on leads. They run well off the footpath into the woods belonging to this neighbouring farmer who's asking the question. 2 of the dogs were recently seen bothering sheep in their field, and one of the dogs chased and attacked the farmer's own dog as they approached the public footpath from their own land. That's the farmer approaching the public footpath. What are their rights? What can they do to protect both their dog and their sheep?
This is a common problem. We get it quite a lot, particularly around lambing time, for example. And I speak from personal experience. I'm a dog owner. I love dogs. I've also been attacked by a dog, and I've ended up in hospital as a result of it. So I sort of come from every single sort of angle here. It's a criminal offence to allow a dog to attack livestock. So that can be reported to the police, for example. That's the first thing to say. A farmer, as a last resort, can shoot a dog if it's terrorising livestock. The problem is it's a balancing act, because to shoot an animal potentially gives rise to liability, to criminal liability under the Animal Welfare Act. You're not allowed to cause unnecessary suffering to an animal. So if you shoot an animal, you're potentially doing that. But you are allowed to shoot an animal if it's in the course of terrorising livestock. Obviously, that's a last resort. It would be preferable if it isn't in the process of doing that. Firstly, to put up signs on your farm to suggest that passers-by should keep dogs on leads. I mean, that's a responsible thing to do. If it's a particular dog walker with a particular dog that you know about, then actually writing to them yourself or getting a solicitor to write to them and asking for them to put their dog on a lead is a sensible thing to do. If they refuse to do that, then I suppose the last resort is to actually get an injunction against them to stop them doing it. But again, we're talking sort of cost as a last resort. So I think signage is important. If they've actually caused injuries to your animals, regrettably I've seen that all over the country, then you can claim damages, because any keeper of a dog is what we call strictly liable for any damages that dog causes. And the word strictly liable, or the word strictly liable, mean that there isn't a defence. If you keep a dog causes injuries, a dog commits or causes damages, then the owner is responsible. There isn't a defence. So they're your sort of avenues.
Okay, thank you. We seem to have temporarily lost Carly on camera. I don't know whether the gremlins have got into her camera, but I think we may still be able to hear her. Are you there, Carly? No. Well, we can't hear her anyway. Hopefully we can get her back. We'll carry on with some more questions. Another one about this one's about poachers. Again, for Russell probably. These farmers have a wildlife camera that recently kept with 2 poachers in their woods. They were well off the public right of way, carrying a rifle with night vision equipment and a tripod. Who should they report it to? And are they at any risk of breaching privacy laws by using the wildlife camera near a public right of way, even though the camera is sited on their land, on the farmer's land, the questioner's land? Yeah.
A lot there to think about. It should be reported to the police, for starters. You can't just go wandering about the countryside with guns, so that's a criminal offence. I believe shotgun-related type offences, potentially minimum sentence of 5 years in prison. So report it to the police. That's the first thing to do. It is a civil trespass, so you could apply for an injunction to stop these people doing it again if you wanted to. I wouldn't want to be doing that, I think, with poachers with guns, but personally. On to the second part of the question, which I think related to the CCTV. You are able to touch
Lighting of a wildlife camera.
wildlife. Well, it's similar to CCTV.
What's one and what's the other?
Yeah, this question revolves around data protection, what we call GDPR, which is relatively new. GDPR and data protection doesn't apply to your residential property. Now, the problem is most farms are residential but also commercial. So best practice would be to treat the whole of your farm as a commercial property, probably the sensible thing to do. In which case you've got to be careful of data protection regulations, in which case you can't keep data about people, which potentially is caught on camera, without letting them know about it. So if you've got wildlife cameras or CCTV out on your farm, as distinct from your actual house, which is perfectly reasonable because you'll probably want to put them up near expensive farm machinery and that sort of thing, then you should stick up some signage, just making people aware that they're being filmed effectively, and you should also report it to the Information Commissioner's office, and let them know.
Okay, thank you very much, Russell. We've got such a wide range of questions here. Another one which we've actually had in during the broadcast is, again for Russell, can you explain the process of how to force the sale of a jointly owned property?
Yeah, well, it's ideally you can sort it out with your joint owner. That's the best and cheapest thing to do. But sometimes it's not possible for a variety of reasons. Sometimes because one person's living in the property and the other person isn't. I mentioned the Act earlier. It's the Trusts of Land and Appointment of Trustees Act 1996. Section 14 and 15 are the relevant sections, and it basically says that where there are two or more owners of a property, if you can't decide how to deal with the property, it's open to one party to issue court proceedings to ask for an order that the property be sold, and then the proceeds of sale split between the parties. And then I think it's Section 15 of that Act sets out the criteria that the court or a judge would look at when deciding whether to order that sale. So one of the criteria is whether or not there is a youngster or someone under the age of 18 living in the property, that sort of thing. And there are other factors to have regard to, but usually the judge will just say, sell the property, split the money.
Construction company using the farm name. They've got access on the farm.
Can't quite hear you, Susie. Oh, sorry, I couldn't quite hear you there.
Right, it's probably for Russell and for James. Can you hear me now?
Yes, that's better.
Construction company which has use of the farm lane with unlimited access to a project for the last 18 months. They have a verbal agreement that the lane would be repaired and resurfaced when they withdraw. The company are now reneging on this agreement and negotiations have been tenuous. So, James, what do you think from that? Because I've come across this sort of thing. And
yeah,
because what you said in the beginning about getting everything lined up before.
I fear to say this comes back to the very beginning that I said is clarity of communication and getting it in writing. We do a lot of these sort of agreements, whether it's with acquiring authorities of one form or another, or just people wanting to go across third-party land to go and deliver a project, such as in this case, as I see it. What I would strongly advise is you should have had some form of license agreement drawn up, which would set out how you would deal with, probably got a record of condition done at the beginning, a record of condition at the end, compensation clauses or provisions within the license agreement, and also, how are we going to deal with legal or professional fees, whether that's a surveyor putting in a compensation claim, making sure that your surveyor's fees are covered, or at least they're reasonable fees covered. That often can also lead to an argument. But the answer is, you want a sensible license agreement in. You want to have within that license agreement provision to say probably a record and condition at the beginning, a record and condition at the end of the particular track. You want to ensure you've got reference to how a dispute, if you can't reach an agreement at the end of the day, how would that dispute be resolved? Would it be expert determination, arbitration, go to court, that sort of thing? And obviously within it have a compensation clause written in that says, the contractor or whoever it is who's in charge of this project will be responsible for putting any damage right, or reinstating land to a reasonable condition, or putting the damage right at the end of the day. How you actually achieve that is often can be difficult, because quite often we've come across situations where a project will end, let's say in the middle of November on a wet day like this, and the field is just not in a condition you can ever reinstate it. Well, certainly probably not till next April, May. So, at that stage, you then probably want to realize that could be an issue at the beginning, get in writing that, you would reinstate it the following April, May, or whenever it is, if ground conditions aren't suitable to reinstate it at the time the project finishes. But there's quite a lot to think about. And if it's unwritten, what you'll probably find is the original contractor or the original person you spoke to may not even be on the project anymore. It's all been subcontracted out, and the people who are left there doing it, who finish off the project, may not be the people you spoke to at the beginning, and it is a problem. But I think the answer is you put in a compensation claim, and if they won't pay it, then you would then probably have to give Russell a ring.
Yeah. Okay. So, Russell, assuming they've done that and it hasn't worked, nothing's happened. We're over to you on this one now.
Yeah. Well, I think you mentioned at the beginning of the question it was just agreed orally, and that's a question of evidence. Again, it's best practice to have everything in writing. If it's not in writing, as the case may be, then it's a question of evidence. So effectively, you are asserting that you agreed orally that you would be compensated for damage to the land. And the best practice would be to write to the other side and ask for compensation for that. And if they don't agree, then your only real option again, but for sorting it out via settlement mechanisms, mediation, etc., would be to issue court proceedings and claim damages for it. Your sort of sticky wicket is that you haven't got anything in writing. So what I would say is, if access is still ongoing, then you do potentially have the lever of blocking the access until they agree to compensate you. But that comes with its own risks if you're doing that, because you then might face a counterclaim for blocking access. So you need to find it, I think.
Okay, thank you. This is another one that goes for Russell and James. Should I have to pay rent on land that the neighbours have been grazing for over 12 months simply because the landlord hasn't fixed the fences? So someone else's stock is getting into a tenant's land where the tenant is in occupation, but obviously he's unwilling to pay his rent because the landlord won't fix the fences, assuming it is the landlord's responsibility in that case.
Well,
James.
Well, I think the first question is whose responsibility is maintaining the fencing. In many tenancy agreements, it's not the landlord's responsibility. It's usually the tenant's responsibility to maintain fence against their own stock. So I think you need to go back to basics on that one and work out whose responsibility it is to start with. But if someone else has effectively been trespassing on your land, I think you still got to pay the rent. If you're renting some land, you've still got to pay the rent. Your issue is a claim against the person who's potentially trespassing on your land. And in that respect, you probably come back down to who is actually responsible for maintaining the fencing, which may or may not be the landlord.
Sorry, beg your pardon, Susie. I entirely agree with what James has said. Also, just to add that the neighbouring landowner has a duty to keep their livestock on that land. So, yeah, that's a claim against the neighbouring landowner potentially.
Okay, thank you. We'll go to one for Carly initially now. This person is thinking about making plans for succession, but they're concerned that what they would like to do is likely to cause a problem in the family. Their daughter works in the business with her husband. Their son lives locally. Sounds like the son isn't involved in the farming business, but will expect some kind of inheritance. Son is due to be married, and the questioner is fine with making gifts to the daughter now, but not happy to do so at this point to the son. It might be a question for all three of you, but if we start with Carly on that one, you might have some clever ideas about how to get over this.
Well, it's a really interesting one, and I think if there's the intention to make gifts now, it'd be interesting to know if they're driven by tax planning considerations or if it's just a wanting to make that gift and to pass assets down. I think that it's always tricky, but we're going to come back to being fair isn't equal. If daughter is working on the farm, if daughter is building that business up, she's getting up and at 5 a.m. and doing whatever she has to do on that farm. Son's had the opportunity to leave home, to make his own fortune, to build create a pension pot, do whatever. Fair isn't equal. Daughter may be given X, son may be given Y. It has to just be fair, and this is where we look at potentially diversification projects within a lot of our farm businesses. Is there a way that we can split a little sideline that can go to the non-farming children? Are there a few commercial lets? Are there things that aren't going to be devastating if we lose it in the main farm business? Is the farm viable to go two ways? Possibly not, in which case we have to find a way to secure that farm for the future if that is the main aim of everybody involved. And for me, the initial step here is opening that dialogue. It's having that conversation. I completely agree, and I understand and I empathise with people who are reluctant to make gifts to people that are just getting married. I think that's quite a common thing. Potentially Russell can come in on the prenuptial agreement discussion, but it's something that we understand works, we understand is a useful tool here. And I think, obviously the standard discretionary trust option is always one to protect assets if we're worried about, divorce down the line. So I think the key here would be, let's open that dialogue. This problem is not going to go away in 2 months, 5 years, however long you leave it. It's only probably going to get compounded. So let's open that dialogue. Is there a reason that we're thinking about this now? Has there been a diagnosis? Has there been a developer sniffing around? Have we got some opportunities there as well that we need to think about from a tax perspective? But if our priority is carrying on the business and keeping our family together, we need to talk about this. We need to get it out there in the open. Having a third party, whether it's an accountant or a lawyer, I do find, Russell, it's nothing personal to you, I do find sometimes that lawyers can be fairly confrontational. If you sit down with a lawyer, it might feel like there's immediately going to be an argument. With us, we can look and we can sit and look at accounts with you and discuss things sort of a bit more casually, potentially, because we're not so on the record as lawyers can be. But I really think it's key to open that dialogue, get everybody around the table if that's possible, and just explain. And if everyone's reasonable and logical and we can put that forward, then you would hope everyone will be pulling in the same direction.
Okay, thank you, Carly. I'm skipping about a bit subject-wise. Just looking for one of the questions that's come in during the session is back to Russell on this is a sort of boundary dispute, and we with Business Clinic in Farmers Weekly we quite commonly get questions over boundaries, hedges, access, shared access. This one is, we have a border dispute with a neighbour who's claiming a strip of land despite the title deed showing the line. we've been told that the title deed is not proof of where the border is. Russell, I've had queries from people into Farmers Weekly also, which we probably ought to put to things, about land registry maps and things not being correct. So perhaps you could talk a bit generally about that and then address this question as well.
The first thing to mention is probably something called the general boundaries rule. So if when people talk about deeds, they might be talking about what can be seen at the land registry. The land registry just shows what we call general boundaries. There's no guarantee of precisely where what we call the legal boundary is. The legal boundary is something that is created on the first occasion of two parcels of land being split. So once upon a time, the land was owned by one person. At some point in time, that land's been split and the boundary's been created. Now that would have been done by way of a deed, and it is that deed which will be the key document to consider to determine where the boundary is. Some deeds are very descriptive and have very clear, precise measurements on an attached plan, for example, and make it quite clear that they show the precise location of the legal boundary, whereas other deeds perhaps just say we attach a plan for identification purposes only, and you've got a big fat felt tip pen showing where the boundary is, and you know, it could be 5 meters this way or 5 meters that way. Now that's not quite as clear. So in those circumstances where the deed is not perfectly clear, then what the court would do, I say court because if it got that far, that the court would determine it, would look at the features on the ground, perhaps, to see whether they illuminate where the boundary might be. It might not, because what's happened on the ground may have changed over many, many years. But equally, sometimes you might have a fence that's been in place, a metal fence for 100 years or so, and that could be quite indicative of where the legal boundary was. And then, failing of that, we have other ways of determining the boundary. You sometimes have presumptions. So there's something called the hedge and ditch presumption, for example, and that's often if you own, the presumption is, might not always be correct, but if you own land and you were to dig a ditch, you would dig it right up to the sort of extremity of your land, and you would then put the soil back on your land. So the theory is that the right to the edge of the ditch is on your land, for example. That's a presumption. Failing all of that, then we might be looking at expert evidence, and I know probably not James himself, but someone within James's his firm, for example, would be able to come out and perhaps sort of provide an opinion, an expert opinion on where the boundary is, perhaps sort of mark it all by way of GPS referencing to looking at old ordnance survey maps and that sort of thing, and find some consistent objects or houses, that sort of thing, which have been in situ for many, many years, and try and plot where the boundary is most likely to be. So lots of things can be taken into account. The start is the original deed which created the boundary.
One point which I think is often commonly missed or misunderstood is that ordnance survey boundaries in the countryside, they don't guarantee them to be more than a couple of meters correct in the correct position. So there's masses of scope for people will brandish a ordnance survey map and say, well, that's where the boundary is. It's not been measured to that degree of accuracy. And you often end up in boundary disputes arguing over distances which are really beyond measurement. And then it comes down to, often comes down to emotions get in the way, and they become a massive dispute over something where, you could be talking about 6 inches and there's no real way of resolving it one way or the other, because there's too much noise in the data, if you like, and it's difficult. You can waste a lot of money on a boundary dispute.
Yeah. Okay. Thank you very much for coming in there, James. We've just got a minute or two left. So before we run out of time, thank everybody for their expertise, their time, and apologise to our audience because we haven't got near all of the questions. We will try and get some of them answered for you outside of the live event if our panel are able to do so. So thank you very much to everyone. We've covered a lot of ground. I think there must have been a lot of sort of food for thought, and hopefully it will prompt some discussions around the kitchen table in some farmhouses over the next few days, and perhaps get some things moving that have been a bit stuck so far. So that's great. Thanks very much, everyone. I think we've just got 1 minute to go. Very quick question. Probably Russell, what are the options to deal with my neighbour's potentially destructive rain runoff onto my land as a result of altered drainage? We assume there that it's the neighbour who's altered the drainage. I don't know if you can do that in half a minute.
Yeah, I'll give it a start. So there's a difference between natural rainwater runoff, which typically you can't sue for because rain falls and it travels wherever it lands. But in order to have what we call a nuisance claim, typically you need, if someone has changed their land in some way, if there's an unnatural change to it, you've built something on it, you've built a hill, you've dug a ditch, whatever it might be, and the rainwater is running onto a neighbour's land because of that change, then there is a duty of care, and you've breached that duty. There's probably a claim of nuisance, but it relies, as I say, the key point is if there's been a change to the land, sort of a man-made change, then there is a claim for the damages.
Okay, that's great. Thank you very much. That was very quick. Thank you. Right, I think we are just about on time now. So again, thanks to everyone, and I hope it's been useful. I've certainly learned a few things.
Thank you.
Thank you. Good night.